Let's begin, though, in Massachusetts with an update on today's motions hearing for Karen Read. Joining us now with the latest is Court TV crime and justice correspondent Matt Johnson. Matt, thank you so much for being with us. Talk to us about this motions hearing today, and the Commonwealth is asking for more cell phone records.
Yeah, you know what? That is the crux of this, and some of the biggest evidence that the Commonwealth has. Commonwealth claims that Karen Read knew that she hit her Boston police officer boyfriend, John O'Keefe, during a blizzard back in 2022, and then they claim that she called her dad that night. Well, now they want the cell phone records from William and Janet Read. Karen Read's parents seated in the gallery today, listening very closely behind their daughter, listening to these arguments. Take a listen.
When Miss Read knew that she struck John O'Keefe is a critical issue in this case, simply because the government has significant evidence outside of phone records to support and to convince that Miss Read knew she hit John O'Keefe when she did. The government's entitled to the full value of their proof.
The Commonwealth, again, is already in possession of Ms. Read's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Read did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records.
We're back in the big courtroom there in Dedham, Massachusetts today, and it's a packed courthouse as usual with this case. Victim's family seated on the other side of the gallery, we should note. They have filed a civil suit against Karen Read, but that is on hold right now, Kelly, as we're waiting for the criminal case to be adjudicated.
Wow, there's just so many developments in this case, Matt. The retrial might introduce interviews that Read has done. We've been talking about that here on Court TV, doing these interviews for the press. Of course, us, as part of the press, we love getting interviews with people like Karen Read, but now that could be a problem, at least for her.
Yeah, because she's been out on bond, and she likes to speak to the media. She wants to tell her story. She answers my questions occasionally outside that courthouse, but we are seeing a shift in strategy between trial 1 and 2. Both parties stipulated to news clips before the first trial, but they were never introduced during evidence to that jury. Well, today the focus has again been on Karen Read's interviews, including one of the first that she gave to Gretchen Voss from Boston Magazine before that first trial. And now the Commonwealth is asking for more of the notes and recordings from that interview. Take a listen.
Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Read drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Read. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case.
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
So Gretchen Voss, she was on the witness list for the first trial, but she was never called. She has also claimed, like many of the witnesses in this case, intimidation outside of the courthouse. But it sounds by this new prosecutor, this special prosecutor added to the team, that this may be where they're going, is introducing these interviews that Karen Read has done to 2020, ABC Dateline, local media. Her parents did interviews. I mean, they want it all, and this next jury could see it.
Absolutely. So what are we looking at next in this case, Matt?
Okay, so it's still set for 2025. I know that we're time shifting a little bit with our audience so that you don't miss anything, but the judge, she is like holding her reservation on making any rulings right now. Both sides preparing for that trial number 2 to take place next year, January 2025. Both sides say that they need time to prepare. They filed a joint motion for continuance. They're telling Judge Cannoni that they will not ask for another continuance. They just need a little bit more time to prepare because they wanted to do more testing. They want to do more pretrial interviews. And we're also, you're seeing right there, the video from the Supreme Court in the state, the Commonwealth of Massachusetts, where they were arguing this defense wants 2 of the major charges dropped against Karen Read because they claim that it's double jeopardy. We're still waiting on that. That could delay this trial. But what is next in the case, Kelly, is we are still seeing another hearing next month, December 12th, it looks like, where they're going to talk about, bringing in an expert for the dog bite, which is what the defense claims, because again, they claim that John O'Keefe walked into the house, was beaten up and attacked by the family dog, who is no longer with that family. Right. They no longer own the home. There's a lot of things that the public kind of has questions about. But the last minute, the dog bite expert was introduced during trial number 1. So it's interesting to see why we're going to have a hearing about it again and what will be presented in court next month.
Well, I hope we get to hear from the dog expert. So again, if this goes, we'll have to see what happens.
Absolutely.
All right, Matt, thank you so much for all your insight and great reporting on this case. We do want to bring in our guest for this hour to discuss what we've seen so far in this motions hearing. Joining us from Los Angeles, California, criminal defense attorney and former prosecutor, Marie Pereira. Marie, thank you again for sticking around and being with us today. We just heard Matt's reporting on this case, talking about all the developments from the motions hearing. What are your main takeaways from the discovery motions that the prosecution, the Commonwealth, has put forth today?
I do think I'm going to put on my prosecution hat and say that some of it is cumulative, because if they have the phone records of Karen Read showing that she called her dad, why do they need her dad's record showing he received the call? Because it has more shock value, that's why. And you don't let evidence in because of shock value. So the judge has to assess that, and that could be cumulative. But as for the interviews that Karen Read gave, not as a confidential informant to the press, they should be allowed, when I say they, prosecution, to use it, because she said it. Those are her own words. So if they can prove somehow through the interviews that her whole defense is contradicting itself through her words in those interviews, they should be allowed to do that. And who is defense to say what is relevant and what is not? It is not their case to prove. So prosecution can ask for information. As long as it's not privileged, it's not prejudicial or cumulative, the judge has the right to evaluate the validity of those statements and the records, of course.
Marie, defense is going to argue that it's not relevant. It's up to the judge to make that decision, but of course that's what defense is going to argue. Well, I don't know.
That's what they're going to argue. They're going to argue it, but who is defense to tell prosecution what is relevant in their theory of their case? They have the higher burden. So they're going to be given a lot of, laxity when the judge is making this decision.
Absolutely. All right, Marie, thank you so much.